All right. I'm a bit of a boomer. Let me just make sure that everything's going good. Awesome. All right. Sorry about the short notice stream. I have a lot going on. My life is fairly busy right now. But I thought I'd talk about a couple things. We are going to get to Earl's, at least the first video that he made about his Deer Park PD case. But first, I want to talk about this is from Krista Hemming. Earl claimed that she was his attorney and that she did terrible, terrible things to him. Now, the way a complaint works in California, at least, if you make a complaint to the California State Bar about an attorney, the first thing that the State Bar is going to do is, well, they will initially look at the complaint to see if it's something that makes sense, to see if it's something that is a violation of the rules of professional conduct or the business and professions code. If it's not a violation of either of those, then it's not going to go anywhere. They're going to look to see if you were actually the attorney's client or if you're alleging some sort of a client type relationship with the attorney. And if you hear dogs walking around, I apologize. But then what they'll do is they will contact the attorney. I have received one complaint that actually made it to me. It's for somebody who actually was a client. So, and mine was also found to be without any, it was without merit is what they found. So, I'm kind of familiar with the process, and I have defended other attorneys to the California State Bar who've also received complaints. So I have some familiarity with this. Now the way it goes is the State Bar contacts you. They send you out a form letter. Well, part of it's form letter, part of it's custom to you, where they lay out the allegations to you that the client made. And these are just allegations. They don't have to reference any sections of the Business and Professions Code. They don't have to reference any sections of the Rules of Professional Conduct. These are just pure allegations. And the State Bar gives you an opportunity to respond to these allegations. So you get to write to the State Bar addressing these allegations, stating what you believe happened, giving your evidence. And in addition to this, the State Bar will ask for all notes that you took, documenting any phone conversations with the client. They will ask for basically your entire case file, every document that you've ever generated around this client. And then the State Bar, there's an inspector. They blocked out this particular inspector, Krista did, and that's fine. But then what the State Bar will do is the State Bar will then investigate. Think of this like a criminal investigation. If you allege that someone did something to you, to the police, you don't have to know the right statute to cite. You don't have to know whether it is or isn't against the law. You just make the allegation, and then the police will do an investigation. And then it'll go to, so these guys are like the police, the investigators are like the police, and then it'll go to an attorney. The State Bar has attorneys that work for them that are different than the investigators. The investigators are kind of like the police. Then after the investigators get everything, they'll send it to an attorney, just like the police would send it to a district attorney. And then the district attorney is the one who would actually figure out what sections of what code you violated. So in a criminal matter, at least in California, they would look at, generally speaking, the penal code, although there's also the health and welfare code for drug violations, things like that. But generally speaking, they'll look at the penal code and they'll determine what section of the penal code you violated. With the State Bar, they will look at the Business and Professions Code and the Rules of Professional Conduct to see what you violated. And just so you know, there is one section of the Business and Professions Code, I forget which one it is, but basically it's a catch-all. Basically, it says that as an attorney, you can't do anything that would, show that you are untrustworthy or that shows, I forget. Let's look it up. I'm typing one-handed, so Oops. There we go. Business and Professions Code. Awesome. Blossom. And then we're looking for 6800. Hello, doggy. I'm not here to pet you right now. 6800-ish. Mm-hmm. Don't look at me like that, dog. All right, paralegals. Here we go. Here we go. Here we go. It's something around in here. Here we go. 6068. It's the duty of an attorney to do all the following. You got to support, yada, yada. You have to maintain the respect due to the courts of justice and judicial officers. Yada, yada, yada. You have to cooperate and participate in any disciplinary investigations. Comply with all conditions. You can't. So I've seen attorneys get disbarred over, not disbarred, excuse me, disciplined over getting a DUI. But basically you have to follow all the laws of the state of California and of the United States, and I don't remember exactly what it says in here. That's the problem with doing these as a live stream. You can't stop and double check what you're looking at. Yeah. So basically, if you do anything wrong, the state bar can discipline you. So if the state bar does investigate, it is a thorough investigation. They have looked at your entire case file. They've looked at every document that you have generated or received on behalf of that client. And if they come back with the matter does not warrant further action, what that means is that after taking everything into consideration, and I assure you that Krista Hemming did not hold back any documents from the California State Bar, unlike what Earl alleges that he did. But after having looked at everything, if the State Bar comes back with does not warrant further action, you're good. Now, yes, it does say it's without prejudice, because if at some point in time they do find something, like that you did something that does warrant further action, then they will take it up. But that's just standard language. Just like any investigation by the police, if they investigate you and they find whatever you did to not be a breach of the law or a legal violation, a violation of the penal code, then that doesn't mean that they can no longer investigate you on that. And we'll see that in the video with Earl. So that's Krista Hemming. She was cleared by the State Bar, and Earl is full of shit when he is alleging that she did something wrong. So there you go. Take that with a grain of salt. It's actually been investigated by the California State Bar thoroughly, and there's nothing to it. So let's see if we have any questions going on. Ever thought about collaborating with Recato Law and talking about Earl's case? No, I don't really care for anything like that. All right, so on to the video. Now this is at 1.5 times speed. So see 1.5 times, and we're gonna get through as much of it as we can before the wife gets home.
I don't have any super good things to tell you, but I got some interesting, we'll call them tidbits for right now. It's going to be an interesting few minutes. I'm not going to stay on here for a long time, but
hour and 47 minutes.
Things that I've not been able to talk about stuff, and the trolls know that, and the police know that. So what have they been doing?
I haven't been able to talk about stuff, and the trolls know that, and the police know that. So what am I going to do? I'm going to talk about it. That's a bad plan, sir.
They've been making sure that their narrative is out. Okay, and I can tell you that their narrative is all lies.
Well, if Earl David Warden says it's all lies, I mean, the man lies about his first name of all things. And there was a long time when it was, yeah, my name's David Warden. Warden like prison warden. Yeah, no, it's W-O-R-D-E-N, not W-A-R-D-E-N. But nice try, Earl.
Well, I'll wait a minute. Let's get a few more people in here, and and then I'll get started.
Oh,
I said
the
7
wife's
o'clock.
home.
Give them 2 more minutes, and then we'll get rolling.
Hold on a
I'm
second,
doing
guys.
good. I'm doing real good. Life's good.
Let me mute this for a little bit. Let me see if I can get permission to continue for a bit. Well, I don't even know how to mute. Thumbs up if I'm okay to. I got the thumbs up. All right, so we're good. Sorry about that.
Just kicking back, relaxing, and I've made some reservations. I actually made a reservation last year at a place in Nevada to take the McGregor to. I've made some other reservations for March on the East Coast, where I'll be taking the McGregor. Basically,
Well, making reservations is all fine and dandy. It doesn't mean that he actually thinks that he is going to be found not guilty. It just means that he made reservations. This could be bravado.
go out there and cruise the Barrier Islands. Again, I don't want to give too much information because
What would be interesting would be if he actually showed receipts, but obviously he showed receipts in the past that were apparently doctored, i.e. receipts to Krista Hemming. But it'd be interesting to show receipts like where he actually put money down on these reservations. That would be interesting.
the idiots will be, in full force out there hunting me or something stupid.
Yeah, idiots are going to go to the Great Barrier Reef to hunt Earl because he's that important. Just like Earl went to South America to hunt Nazis.
Whoever knows. Okay, we 7 o'clock? No, we're about, look at 30 seconds more, guys. Bear with me.
Let me see if I could do something here so that we can maybe have, that's kind of what I wanted here, but then I want this, and we'll stretch this out, and we'll do that. How about that? Then we can actually, you could actually see what people are saying, and there you go.
Bear with me, please. But yeah, I'm just prepping for some trips. I'm gonna spend probably most of the fall, most of the spring, going place to place with the McGregor with the sailboat and doing some work with that.
Oops.
And just enjoying myself. And because the summer will be too hot, so I'll be more likely to.
I'm obviously not coordinated enough to
not do a lot,
multitask.
and then fall back to work. But this spring is going to be cruising with the Mac. That's my main focus. And I'll be doing videos at the same time while I'm traveling. But
Cruising with the Mac. What he means is mac and cheese from his prison cell? I don't know. I'm joking. Obviously innocent till proven guilty.
that is my goal. Let me see here. Okay, good deal. All right, let me see. Okay, we're at 7 o'clock, so we should have enough people here now. 125 viewers. That's a start. Everybody else will jump in as we go. Oh yeah, moderators. Any trolls, ban them, block them.
Yeah, all my moderators who are in my live stream chat here, go ahead and block and ban any trolls. Because people say hurty things on the internet is bad. I don't want to see hurty things on the internet.
Zero tolerance for trolls. Teresa and her crew don't get to come in here and act a fool. And I know they've all got 60 accounts. Well, they can burn all 60 of them. Block the trolls.
Block the trolls.
Where I come from, if somebody doesn't want you around or they say go away, okay, so the trolls are trying to call me on my phone. I'm not on my phone, so you can keep trying to call. You're not interrupting the stream. My internet is not coming from the phone. You're not doing anything. So
The female fish are afraid of him.
because they don't want the truth to be known, especially the trolls. But yeah, they've all got 60 accounts, and they'll come in under different names and just keep coming and just keep coming. For what? Where I come from, if somebody says I don't want to talk to you, you go away and leave them alone. But you see,
This is the same guy that if someone doesn't want to talk to you, you go away and you leave them alone. This is the same guy who is constantly showing screenshots of discords that he's not welcome into, saying that he's in them. I mean, I don't think you're welcome there, Earl, but yet you're there. You're showing screenshots, or you're showing pictures that allegedly were posted by your alleged victim daughter. I mean, I don't think she wants you around, brother. Like, where I come from, if people don't want you around, you don't hang around.
see, that's not good enough for them. That's not what that doesn't suit their purpose. They don't get to force you to pay attention to them, and that's what they try. Here. That's funny. Okay, so I can fix that. We'll just turn the phone off. It doesn't matter. I'm not on the phone. So, there you go. So now you can't call.
And Michelle says he's the one with 60 accounts, I'm guessing. We know that he had multiple Facebook accounts after his David Warden, W-A-R-D-E-N account on Facebook got banned. He came back with David Liberty, which I believe also got banned. We know he's had at least 2 YouTube channels because he allegedly posts on under his he posts under his allegedly his son's account, News Now Community. He contacted me under a different YouTube account name. I forget what it was. Back when I first started streaming, he was gonna make me famous. I declined, of course, but he definitely has multiple YouTube accounts, and he's had multiple Facebook accounts, and I'm assuming he has multiple Twitter accounts. There is a provision of the I don't know which code it is in Texas, but registered sex offenders, they have to notify, I think the Texas Department of Prisons, something or the other. I forget what that's called, but he's supposed to notify them of his online social media accounts, and I am seriously doubting he's in compliance with that, but big deal.
It's probably Deer Park PD doing it. All right, let's get this party started.
Yeah, let's get
so
started.
Now they get a call because I turned them off.
I like when parties
this
get started.
For those of you that don't know, at the behest of the Shell refinery in Deer Park, the Deer Park Police Department 4 years ago initiated a criminal investigation, and they dug into everything in my past. They dug up girlfriends from 1985.
So, for those of you who don't know, Earl David Worden there were some people who were recording outside of the Shell refinery for whatever reason, I don't know, but they wanted to, and so they did. And then off-duty officers, I believe Harris County Sheriff's deputies, off-duty officers, and or Deer Park Police off-duty officers were working security in uniform for Shell. And so this aggravated Earl to no end. And then Earl starts making videos where he talks about security risks to the Deer Park refinery, where if anybody knew how to get in there, then they could blow up the whole thing by changing one valve or opening one valve or doing he kept talking about how easy it would be to blow up the Deer Park refinery. And he was also sending threatening messages to the manager of the Deer Park refinery, saying how he knew when the daughters got out of school, what school they went to, where they went to after school, etc., who their friends were. I mean, he was saying all these things that would lead any sane adult, any sane manager of a refinery to report him to the police. And the police, being the police, are going to investigate. And the police found a file on Earl David Worden from the past that had been gathering dust on a shelf, a case that was not closed, and even if it was closed, as we talked about earlier, could be reopened because he was not found not guilty. There is no double jeopardy. Double jeopardy doesn't attach if they close an investigation. Double jeopardy attaches if you get all the way through trial to a verdict and you're found to be not guilty. Or I think maybe if they impanel a jury, double jeopardy. I don't remember exactly. But anyway, double jeopardy does not attach if they close an investigation. So they could always reopen it. It is without prejudice, and they can continue with it.
They dug up ex-wives, daughters, cousins, other old girlfriends, just anything, trying to find something, because this is what they were directed. They get this report. They open up this report that shows allegations that Earl molested several of his daughters, not just one, several. There were several complaints about Earl's behavior with his daughters. Now, these are all allegations. They have not been proven in court. And so I want everybody to remember that Earl should be considered innocent until proven guilty. But because there were these allegations of multiple sexual assaults on multiple daughters, they then went and started asking his daughters and his ex-wives, who may have firsthand knowledge of what was going on, his girlfriends, who may have firsthand knowledge of what was going on. And I think one of his girlfriends was close to underage, I think 17 years old when he was in his 30s or something like that, if I remember from the police interview. So yeah, they start digging in to find out if there is any merit to these allegations that Earl molested his daughters. So
that's why they started contacting everybody in his past.
They were directed, they were given an old case number that had been investigated and determined to be unfounded. And they were given that and told, see if you can make something out of this. Okay? And 2 full-time Deer Park detectives, over 1,000.
So Unclean Hand says all the women they found were 11 to 13, or that's what I heard. The woman he was accused of raping was not 11 to 13. She had been at a bar, so she is somewhat over the age of 13, I'm assuming, since she came from a bar. The daughter that he is actually charged with molesting, I believe she was 14 or 15 when, at least at the time that they're accusing him of actually molesting her. So I haven't heard anything of 11 to 13. I have heard allegations of him touching a younger daughter, but that hasn't made it to an actual criminal complaint. So be careful.
Man-hours each.
So he's complaining that the police used 2 detectives and multiple man-hours to investigate sexual assault on a minor. I mean, if there is anything that I would advocate for more police hours and more resources being directed towards, it is sexual assault on minors. Stop giving out as many parking tickets and really kind of focus on the sexual assault on minors kind of crime area. Maybe leave alone people who are taking photos and videos from sidewalks, and maybe kind of focus your resource on potential pedophiles. I'm okay with that. I don't know if anybody else is. I really don't care if anybody else is, but I'm okay with the police kind of focusing on that.
Digging through file after file after file.
Yeah, dig through those files. Find those sexual predators. Yeah, sign me up, buddy.
100,000 pages of documents.
100,000 pages of documents. That's Earl. If there are 100,000 pages of documents about you being a sexual predator on your daughters, if there are 100,000 pages of documents on that, that's not exculpatory. I'm not saying that means you're guilty, but that's not a good look.
Trying to find something to charge me with. Eventually, they got to one of my daughters, and that daughter and I are estranged and have been for, 12, 14 years or more.
Maybe it's due to you molesting her as a teenager, Earl. That could cause someone to get estranged from you. Maybe. Just saying. But they got to the daughter, or maybe, just maybe, they found a file wherein the daughter alleged that you assaulted her sexually, and they asked her, did Earl assault you sexually? And maybe that's how they, in quotes, got to her, end quote.
And they used her to come after me, basically.
Or Earl, she used them to come after you. Because remember, she's the complaining victim. She is the one who made the claim. She alleged it, Earl. They didn't. They have a complaining witness who said, Earl molested me as a 15-year-old.
She claims that I was molesting her when she was a teenager, and it went on for years and all this kind of stuff.
And all this, see how he brushes that off? She alleged that I molested her as a teenager, and it went on for a couple years and all that stuff. How do you brush that off? How? Oh, Lord have mercy.
So
this is one of the things, like, they could use something like this at sentencing very easily. Because at sentencing, you want to be like, yeah, okay, so I'm convicted of it. Yeah, I'm really sorry. I've learned my lesson. I did a bad thing, and I'm never going to do it again. But this would show a callousness towards it. Oh yeah, I just got convicted for molesting my daughter for a couple years. I spent a couple years molesting my daughter. Yeah, I mean, yada yada yada, blah blah blah. No big deal.
They finally got a DA that would take charges on it because
They finally got a DA who would take charges on it, or they actually finally presented it to the DA, and the DA said, "Okay, let me go to a grand jury." He's glossing over a grand jury. So the DA took these allegations to a grand jury. Now, I am fully aware. I know I'm going to get all sorts of comments on how I don't understand probable cause, but I am fully aware of what probable cause is. The DA, and I'm fully aware that a DA could indict a ham sandwich, which all the DA has to prove to get a grand jury indictment is probable cause. So the DA took this evidence, these 100,000 plus pages that Earl is alleging, to a grand jury. And the grand jury looked at the evidence and said to themselves, you know what? A crime was probably committed, and Earl probably did it. So it's not just the DA, it's not just the police. A grand jury has looked at it. Now, again, I am fully aware that a grand jury would indict a ham sandwich, but a grand jury did indict Earl. So think about it. I mean, just let that rattle around through your brain a little bit and think about it. I mean, this isn't just coming out of nowhere. They dotted their I's and they've crossed their T's. So, they think that there's something to this.
Case was more than 25 years old. And they finally got a DA to take charges on it, and they arrested.
So the case was more than 25 years old. Well, what's the statute of limitations on that, Earl? Oh, wait, there is none? Oops.
I made bond and hired a lawyer, and that was their mistake.
Oh, yeah. Earl lured them into his devastating trap where he got them to indict him for felony sexual assault on a minor. Boy, they played right into his hands. Just like I played into his hands by getting dismissed from his stupid lawsuit because he was too stupid to get me served, even when I said he could serve me by mail. And then played into his hands a second time when his entire lawsuit against Teresa Richard and the Hemmings and everybody else was dismissed for failure to prosecute. Oh boy, played right into his hands.
Because in the course of, now I'm arrested and charged with something, they have what's called discovery.
Mo, yes, his court date is, I believe, the 24th of February. So in about 19 or so days.
That means I get all the documents. And they fought.
Well, so he's saying he gets all the documents. I don't know that he gets all the documents. His attorney would get all the documents. Hey, WTT's in the house. Welcome, WTT. His attorney would get all the documents. His attorney has probably shown him relevant bits of the documents, but Earl doesn't get the documents. And if Earl is getting the documents, then the judge is probably going to have a word or two with Earl's attorney. So there are considerations like on the documents. There would be I'm using California as an example. So when I have received documents in a criminal matter from the DA, there's always been instructions that you cannot give the DA like the address and phone number of the victims, the addresses and phone numbers of the police, et cetera, et cetera. So they will strip out that information. As an attorney, you'll strip out that information before you show them to your client, and you don't give them to the client. So, I mean, they're part of the case file, yes, but they're not for the client.
They hired a big, expensive law firm out of Austin, Texas, and fought giving me documents, giving my lawyer.
I would be surprised. I haven't seen anything in the settings in the Harris County Court records showing that they hired a law firm to fight Earl. I would be surprised. Now, I know they hire public defenders. At least Texas hires. They have like a public defender pool of private attorneys who will represent indigent defendants, and the county or the state will pay for it. But I'm not so sure about a DA hiring a private law firm. Interesting.
Documents. And by the way, I have the second best lawyer in Harris County.
I have the second best lawyer in Harris County. Number one, I would want to know how that ranking was established and who's the first best.
Fought giving up the documents. Why? I'm entitled to those documents. They're part of the investigation. They didn't want to give them up, so they fought it.
Well, so it's called a Brady motion to get documents that you're entitled to. You are entitled to all the documents that would either establish your guilt or support your innocence. That's federal law. I mean, your Fifth Amendment due process right means that the prosecutor has to give you all the documents that would incriminate you and all the documents that would exonerate you. So if there is a question on something, if something's relevant to guilt or innocence, then yeah, there would be a fight over it. The DA might not want to give up things that are not relevant to the guilt or innocence of the defendant. So that might be why there was a fight, if in fact there was a fight. You got to remember, I just want everybody to remember what we're dealing with here. This is Earl David Warden, and if his lips are moving, he's lying. So, keep that in mind. So take everything he says with a grain of salt. I will, generally speaking, I will give him some credit, undeserved, that what he's saying might have some grain of truth to it, but that doesn't mean that there is anything true in what he's saying.
The reason they did that is they didn't care if the case moved forward. They eventually did give up most of the documents. They still haven't given them all up.
I'm sure the DA cares whether or not the case moves forward. So generally speaking, the rule of thumb is defense wants to drag out a case. It's in the defense's best interest to drag out a case because witnesses forget things, witnesses die, witnesses become unavailable. Things happen. Like take, for example, James Freeman's case, where the Fort Huachuca case, where the security guard, I think it was a security guard. He might have been an MP. The one who arrested James Freeman was separated from the military. He was no longer available as a witness, and I think it is based on that the charges against James Freeman were dismissed. If you don't have the complaint or the person who made the arrest available, you're going to have a hard time proving where James Freeman was, et cetera, et cetera. So generally speaking, it's in the defense's best interest to delay the case, not in the prosecution's best interest. So it doesn't make a lot of sense that the DA would want to drag things out.
But we got enough of them that the picture became clear.
Another thing is you have a due process right to a speedy trial. So generally speaking, the defense they do what's called waiving time. And what that means is that they're waiving your right to a speedy trial. And Earl's attorneys could have not waived time. And I believe, and maybe this is different in Texas, but in California, you can rescind your waiver of time, which puts things back on a time frame to get things done. So because Earl and his attorney did not do that, that makes it appear that it was, in fact, in Earl's best interest to keep things slowed down.
These hired mercenaries.
Because
They're not police officers. Police officers serve their community. They are hired.
Police officers are actually employed by a city to police the laws of that city. So, I mean, that's like saying plumbers are mercenary. Oh, this plumber didn't fix my sink, so he's a mercenary. No, he's a plumber. It doesn't make any sense.
Mercenaries. They were paid by Shell to target me and make every attempt to ruin my life. Shell was paying police officers and deputies to provide security for the Shell refinery.
during their off hours as a second job. I would be surprised if Earl has any direct evidence that the police were paid to investigate Earl. Now, even if they did, that doesn't change anything. That doesn't change the fact that the DA thought there was probable cause based on the evidence that was placed in front of the DA. And that doesn't change that a grand jury found that there was probable cause based on the evidence that was placed in front of the grand jury. So whether or not Shell paid off the police is irrelevant.
Paid them to do that. We have the documents to prove that.
And I seriously doubt that he has documents to prove that.
The-
If he had documents to prove it, that means the DA would have seen that the police were taking bribes. And if the DA saw that the police were taking bribes, I guarantee you that the DA would do something about it. Not because the police took bribes to incriminate Earl, but because the police would then be susceptible to taking bribes to not investigate other people. So, the DA has a job to do to clean up the city, yada, yada. And I seriously doubt that there are any such documents. Because you got to remember that this is the same Earl Warden who had a thumb drive full of documents that were going to incriminate, who the hell was it? I can't even remember the name of it now. Leon Valley. He had the thumb drive, the infamous thumb drive. He had recorded statements from Olmos Park with his little dish microphone that they were going to rape. God, I don't even remember the gal's name. Ecstasy Prez's woman. I forget her name. I'm sorry. No offense to her or him. But I mean, he's had all these documents and he has not produced any of them. And when called out about the thumb drive, I don't know if anybody remembers, but that was just another lure to get Leon Valley to do things or say things or whatever. And it worked out exactly the way he planned.
The payments didn't go to the police department; they went to their private residences. Because if they went to the police department, that might have exposed.
Yeah. So in order to get any evidence of payments direct from Shell to these police officers that went to their private residences, it would not come from the DA. They would have to subpoena the Deer Park refinery, which is, I believe, its own company that is mostly owned by Shell, or 50% owned by Shell and 50% owned by the Mexican Petroleum, the Mexican State Petroleum Company. I forget what they call it. But it wouldn't come from the DA. They would have to do some outside digging. And yeah, I seriously doubt this.
No, they didn't.
I didn't see any subpoenas being issued on that to Deer Park. So I'm not, and I don't even think it would be relevant. So I don't know why subpoenas would issue on that.
They went to their private residences.
Buck G. Thank you, WTT. Yeah, her name was Buck G.
And all of this is documented, and a lot of it's already in the court record. And what isn't there is going in. So before I go any further, I'm going to show you guys some stuff here in just a second.
It's going to go in the court record. So the only thing that goes in the court record really is what you can produce at trial. So you submit your evidence to both sides exchange their evidence. Even the defense has to give the prosecutor what evidence they plan on admitting into evidence at trial. And then you can reference documents, like use them as exhibits, but that doesn't mean they're admitted into the record at trial. It just means like you could hand them a piece of paper and say, do you recognize this document? What does it say? Blah, blah, blah. But that doesn't mean that particular document is going to be admitted into evidence. Generally speaking, after you've established the truth or falsity of the document, then you can move to admit it into evidence. And as long as you can overcome whatever objections the other side has, then it will be in the court record. Now, a lot of the problems with the allegations that Earl's making is it has no bearing on Earl's guilt or innocence. So, I mean, the police could be totally corrupt, and that would be its own separate criminal investigation and or civil suit. But it has absolutely nothing to do with Earl's guilt or innocence. So, I mean, have fun, Earl, but it's completely irrelevant.
But before I go into that, I want to tell you, February the 8th, we have a pretrial hearing, and then we're going to pick a jury if the DA doesn't drop charges. We're moving forward with the case. All right?
We're moving forward with the case. He says that like he has any real standing to stop the case. Yeah, so February 8th, he's picking a jury. Congratulations. And if they don't drop the case, it's been a couple years now, Earl. It's been a couple years and a lot of time and effort over this. I don't think that the DA is going to drop the case. I mean, if you're still hanging on to the DA dropping the case at this point, it would be much more likely that Earl would settle the case. And I don't know if he's actually going to settle the case, but it'd be much more likely that Earl would settle the case at this point than to have the DA drop charges.
Right? They have put this case off. They keep saying it's us. It's not us. Okay? We subpoenaed evidence, and they did not supply the evidence, so of course we reset a few times.
They keep saying it's us, and it's not us. Oh, so we reset a few times. I mean, you literally just contradicted yourself, dude, in the same sentence.
Okay? But it's because they were not giving us the evidence. They're hiding the evidence.
They're hiding the evidence. The evidence is completely irrelevant to my guilt or innocence.
February the 8th, we move forward with this case. If you can possibly be there, if there is any way that you can be there, I encourage you to do so. I want you there. I don't want you to listen to me saying, hey, I'm innocent, I didn't do it. I don't want you to listen to the trolls saying he did it. I want you to come there, see and hear the evidence yourself, and make an informed decision.
Yeah, I support that. You should, if you're able to go there, go there. You'll be able to see the quality of the evidence that the DA has. You'll be able to hear the witness testimony that is presented, and you'll be able to see what Earl's attorney is going to present in Earl's defense. And that's all great. And you'll get to kind of see how the trial moves forward, and you'll learn what Earl's lying about and what he's not lying about. So yeah, absolutely go there, see it.
I want you there, please.
And that way you could also, when Earl from prison makes his phone call to whoever still believes him on the outside, and Earl says that it was set up and it wasn't fair, then you'll be able to say, look, I was there, and the judge didn't seem to be biased to me, and the judge sustained some objections on both sides, and he overruled objections on both sides, and it seemed like he was fair. So you'll be able to make informed statements about what you saw on that day, and that'll be a good thing for everybody.
Okay? I want you there because you're going to see the truth, you're going to hear the truth, you're going to know the truth. And then it can't be hidden. And then the trolls can't lie, or they'll still lie, but you'll be able to say, no, I was there, and I heard and saw the truth, and you're lying. There is a Deer Park police officer that has been threatening to kill me.
There's a Deer Park police officer that's been threatening to kill me. So we've gotten past where I've actually watched. Oh no, I think I got a little further than this, but I wasn't paying attention much when I was gotten to this part. A Deer Park police officer has been threatening to kill Earl. Citation needed.
He made the mistake of making a comment on Google, and I backtracked his IP address and found it. Oh, Lord. I backtracked his IP address from Google.
Oh, my God. Holy Jesus fucking Christ. Oh, this is the guy who's streaming with his fucking taskbar showing. Oh, my God. Oh, he backtracked. Earl the super hacker. From his rape shit out front. Oh my God. He's fucking hacking Google to get people's IP addresses. Oh shit. Oh, I fucking need a minute. Oh my God. Oh, okay. All right. Oh, holy Jesus fucking Christ. I didn't expect that. Oh my God. I did not expect Earl Oh God. Okay. Oh. Okay. All right. Okay.
There is a Deer Park police officer that has been threatening to kill me. He made the mistake of making a comment on Google, and I backtracked his IP address and found out who he is.
Okay. Okay. Oh my God. I just. Okay. Oh, Jesus Christ. No, I'm crying. I'm literally crying. Oh, Jesus. Lord help me. Oh shit. I wanna hire Earl. I want to hire Earl for my law firm so that he could do my investigations for me. Oh, we gotta go.
Early on, when I made bond, Deer Park PD thought I was some poor activist. They didn't think I had any money. Well, I do have a little money. And so
This guy is streaming to you right now. This guy with the money is streaming to you right now from a shed. You know, the portable kind of shed that you buy, and then you normally would install it on like a cement pad or something. He's streaming from a shed. He has a green screen behind it. That's not his fish tank. He has a green screen behind it. And then his residence is a trailer. He lives in a trailer. I don't know exactly what you call it, a travel trailer. I mean, so this dude with a bunch of money, and I don't even think the property is in his name. I was looking at suing him for defamation for a minute, and I don't even think the property is in his name. It's in his, I think it's in his son's name or something like that. So, oh yeah, I know the Nazi hunting thing, but come on, man. Like, I laughed at the Nazi hunting thing too. Anyway, so yeah, Earl isn't rolling. So WTT says it's a really nice shed. WTT's been in that shed, and he didn't walk right afterwards.
they were shocked when I made bond. They were even more shocked when I was able to hire the attorney that I have.
They were shocked when I made bond. I think he had like a $50,000 bond, which means he'd have to put $5,000 down. No one's shocked if you come up with $5,000, Earl. No one's shocked.
And so one of the emails that we managed to get from them talks about that. It says, how did he afford that lawyer?
No. His attorney isn't that expensive, and no one is wondering about that or caring about that. So you're lying, Earl.
This case will probably get dropped.
This case will probably get dropped, says the email that he won't show you, and he's lying when he's talking about.
And in the reply to that email, and I'm not going to say who sent the email back and forth, or who was involved in the conversation, that'll come out in the
that'll come out.
civil suit. But
It'll come out in the civil suit that Earl won't hire an attorney to prepare or to file or to serve. It'll come out in the civil suit that will be dropped for failure to prosecute. I mean, whoo, big talk.
the reply to that email was, it doesn't matter. We always knew the case was weak. We've ruined his life.
Yeah. I mean, yeah, this is the worst exposition ever. If you saw this in a movie where the police were like in an email saying, how did he afford bail? Now the case is going to be dismissed. And the other cop replies, oh, it's okay. We already knew his case was weak, and we've already ruined his life. I mean, these are the most cartoonish villain cops ever.
He's ruined publicly. He's done. Stick a fork.
He's ruined publicly. Yeah, the T-Doc Sex Offender Registry. It's not T-Doc. What is it? Texas. Is it Texas Department of Corrections? Department of Public Safety, TDPS. There we go. Let's see if we can do Earl David Warden. There we go. Oh, that's Home Facts, Dickinson. Anyway, so he is a convicted sex offender, but they think that this case is going to ruin his reputation. Right. I had something else I was going to say on that, but I forgot. Anyway, moving forward.
Well, they tried. They worked really hard. They networked with their, they used their network of confidential informants to try and attack me publicly and try to get people to.
They use their confidential informants to attack Earl publicly. Now, Earl's a retard, and I use that term lovingly, who talks about his case openly and publicly. Now, the police, number one, they're not invested into this like Earl is. See, Earl is seeing this case. He's invested emotionally into this. This is me putting on my psychologist hat, which obviously I'm not a psychologist, but I'm gonna pretend I am for a minute. Earl is emotionally invested into this case, and because Earl sees things through Earl's eyes, and Earl wants you to believe things are the way that Earl sees things, he's going to allege that the police are also emotionally invested into this case. And I don't think they are, and they're not stupid enough to talk about it online. There is no benefit for them to talk about it online. Now, Earl thinks there's benefit for him talking about it online because there's probably rumblings going on in his old community, and he's been demonetized from what I understand, yada, yada. But he wants to keep his followers his followers. He wants to keep his sycophants his sycophants. He doesn't want any cracks showing in his armor. And so it's to Earl's perceived benefit to talk about this and to say his side of the story and to make all the allegations that he's actually the victim in all of this. But it's not to the police officers, because if they believe that Earl is guilty of this, then they're going to keep their mouths shut and not give the defense anything to actually work with. They're not going to make public statements. And I've never seen Earl present anything that is definitively from a Deer Park police officer on this case. I have never seen it. And I have actually requested from the Harris County District Attorney, I've actually requested them to make comments on what Earl's been saying, and I have not received back one peep from them. Because, they're attorneys and they're not stupid, and they're not going to talk about an ongoing case to give the defense any ammunition to use against them.
Turn on me. And a lot of weak-minded individuals did.
You're weak-minded if you don't believe Earl, apparently. You're a bad person if you don't believe Earl.
A lot of followers did. All these people that in this, there's a lot of people in this movement that run around saying, never believe anything the police say, because that's all they do is lie.
Yeah, never believe anything the police say. That is a correct statement. All they do is lie is not a correct statement. They can and will lie to you on the street, but on the stand, they're much less likely to lie. So,
unless they say it about News Now Houston, then believe every word of it.
No, don't believe anything the police say about Earl, but also don't believe anything Earl says, period.
They prepared a public statement.
WTT says News Now community is monetized again. Well, good. I don't think anybody should flag Earl's channel or try to get it demonetized. Earl has a right to a defense. He has a right to be able to afford an attorney to provide a good defense in his criminal case. He has a right to that. And I would prefer to see Earl have a great attorney who's paid for, who's fighting for Earl, because that way we'll get justice. Whether Earl's innocent or guilty, I want justice to be done. If he is innocent, I don't want him to go to jail for it or prison or whatever. If he's innocent, I want him to be exonerated in court. If he's guilty, I want him to have had every opportunity to defend himself and to have competent counsel defending him so that there isn't a chance of a mistrial, so that there aren't grounds for appeal. I want him to have the best attorney and the best chance he can get to defend himself. So please do not, and I'm absolutely serious about this. This isn't some backhanded way of saying try to demonetize him. I'm asking you not to try to subvert our criminal justice system to get somebody demonetized so they can't afford their defense. I'm asking you not to do that. Please do not. Never do that. Whether or not you think he's innocent or guilty, let the courts decide. Please.
And released it on Facebook at the time of my arrest. The conversation before they released that public statement, and it was approved by the assistant chief and the chief. And the chief, in the emails, tells them, find the worst photograph of him you can find and put on that. We want to make him look like this scumbag.
Find the worst photograph, or maybe just his sex registry photograph. I mean, that one's pretty bad, right?
Worst scumbag out there. Hired mercenaries. Domestic terrorists.
They're domestic terrorists.
That's who's leading the Deer Park Police Department.
Also the booking photos or anything like that, they're not going to be used at trial. So, I mean, it doesn't really matter.
Law firm in California. I engaged them to handle a lawsuit for me. I have the contract. I made a bar complaint against them. The California bar eventually dismissed it, which I expected they would.
Well, you should have expected they would, because again, I don't know if everybody caught this from the beginning of the stream, but they investigated it and they found that it doesn't warrant further action. Now, again, these are basically like criminal complaints. When you make a criminal complaint to the police will investigate it. You don't have to allege anything other than what happened. That's all you have to allege. You don't have to know any of the penal codes or anything like that. The police will then investigate. If the police think a crime was committed, then they will give the evidence to the district attorney, and the district attorney will then look at the evidence and decide if they can prosecute, and then the district attorney will decide what they will prosecute for. The same kind of thing happens in California with the state bar. You make a complaint to the state bar. You just say what happened. You don't have to know what relevant statutes or rules of professional conduct might have been violated. You just say what happened. And then an investigator, this letter was written by an investigator. This is from Krista Hemming. An investigator will then look at what you have presented and will then they won't send the attorney what you said, but they will send out the specific allegations that you made. They will snip those out that they think are relevant, and they will send that to the attorney along with a request for basically the attorney's entire file about you. Every document they created on your behalf and every document that they received that references you or is in relation to you. So the attorney will then have an opportunity to respond to those allegations in a written format, and they will send the state bar the entire file. And then the investigator will look at that and determine whether or not there's anything further that they need from you or any further action they have to take. There's also an attorney working with the investigator who will probably look at these things as well and determine if there's any violations of the rules of professional conduct or the Business and Professions Code. The Business and Professions Code requires basically that you not violate any law of the state of California or of the United States, and it also requires you to act in an upstanding manner. So if allegations were made, I guarantee you they were thoroughly investigated. If there's no basis to the allegations, if you allege things that just, even if true, wouldn't be a violation of the Business and Professions Code or of any criminal law or of the rules of professional conduct, then the investigation won't go any further. The attorney will never know you made those complaints. If you do allege something, like in this case where Earl alleged that he had retained Krista, that there was an attorney-client relationship, and that she then violated the confidentiality, the attorney-client confidentiality privilege, the duty of confidentiality, then they would do further investigation. So this has been investigated. We know that it's been investigated because there is a statement from the state bar given to the attorney, this was sent to Krista Hemming, that says that it has been investigated and it doesn't warrant further action. So there you go. And just like I've said this earlier, but just reiterating it, just like with a criminal complaint, just because they close the criminal complaint or the criminal investigation does not mean that double jeopardy attaches. They can always reopen a criminal investigation. They can always reopen a bar investigation, and that's why it's saying without prejudice, but that's just because we're lawyers and we deal with that kind of language. But it's not closed just because, right? So let me get both these things back up. All right.
I have to go through the process. I didn't give the bar everything I had because then, because they share that with the Hemmings. I didn't want the Hemmings to know everything I have.
That's a lie. So like I said, they don't give the attorney everything that you allege, and they certainly don't give the attorney any of the documents that you produce. That is absolutely 100% a lie. I have had one of these complaints myself that has actually made it to the investigation stage, and mine was found to be without merit as well. But I've also defended other attorneys on these. And you only receive a letter from the state bar saying specific allegations that the state bar believes are worthy of response. You don't receive the actual initial complaint, and you don't receive any of the documents that are submitted with it. So Earl is lying out of his false teeth.
And that too will play out in the civil lawsuit that'll come with this case.
I wonder what he's going to sue the Hemmings for, and that would be interesting to find out.
The Hemmings think they're safe because, it's been too long, he can't sue it. No. You're an informant in a criminal case that is ongoing. The timer doesn't start until that case ends.
Well, that's news to me. I mean, what statute is he referencing there? There's a statute of limitations that has nothing to do with them being an informant or anything else. So no, he's lying again. There's a statute of limitations. It would all depend on when the alleged wrongdoing took place, the harm took place, and what specific allegation he's making as to, because different sorts of civil torts or contract disputes or whatever have different statutes of limitations. So you'd have to know what exactly he's alleging that the Hemmings did to determine which statute of limitations apply. Generally speaking, it's somewhere between 1 and 4 years, generally speaking, at least in California. So, I mean, his timer is ticking. So he really needs to get his act in gear if he's going to sue him. I'm just saying. I think legal malpractice is 1 year. Let's look it up. CCP statute legal, typing one-handed, malpractice. Act for attorney, 1 year, yeah. So he had a 1 year statute of limitations. So let's see, where is it? So this was December 8, 2020, so it was 1 year's run. So yeah, sorry, Earl David, you're wrong, you're done. Oh, shit, I need this and then this. All right.
They are, here in Texas right now, we are setting records in federal lawsuits against law enforcement.
Records? What kind of records? The number of cases filed doesn't mean shit, because there's a lot of cases filed every year, especially from prisoners, against law enforcement.
You've always been, you might get $5,000 or $10,000. Now all of a sudden, people are waking up.
$5,000 or $10,000. So damages, I've gone over this before in past videos, but damages, there's 3 kinds of damages. There's special, there's general, and then there's punitive. They all have different names as well, but I'm going to refer them to them by by what I normally refer to them as. Special damages are damages that have an actual dollar amount attached to them. So if you get your leg broken, there's going to be the ambulance bill, there's going to be the hospital bill, there's going to be any costs for prescriptions, any costs for physical therapy. Those are actual, you get receipts for those. You could actually prove those dollars down to the penny. Vum.today, I don't know what that is. That's probably spam. Anyway, so those are special. You could actually prove those down to the penny. Now there's general damages. General damages, generally speaking, are some sort of a multiple of the special damages. So the more hurt you are, the more special damages are. The more hurt you are, the more general damages tend to be. And general damages tend to run between 1 and 4 times special damages. It could be more, it could be less. But general damages are supposed to compensate you for pain and suffering, humiliation, yada, yada. So those two things combined set a limit for punitive damages. Punitive damages are, generally speaking, going to be 10 times or less. There's Supreme Court, there's case law that any double-digit punitive damage multiplier is probably going to be a violation of due process. When you're going into these cases, you need to know, generally speaking, how much is on the line, because that might affect how much money you spend on defense. If you are going into a case where your maximum exposure is $10,000, you might spend less money on an attorney than if you go into a case with your maximum exposure of $1 million. So the Supreme Court has said it's a violation of due process. You need to know kind of what your exposure is. So any damage award that is any punitive damage award that is double digits multiplier over what the special and general combined are is presumptively unconstitutional. So if you get, let's say, $1 in special damages and $1 in general damages, you'd be limited to a maximum of $20 or less in punitive damages. So the way damages are based, if you're getting between $1,000 and $5,000, that means that you had nominal damages. That means you had very low damages. That's why. You actually have to prove your damages in court. Most people think that you only have to prove that the police did something bad, and that's only part of the equation. That shows they're liable. If they did something bad, now they're liable to you for the damages you incurred as a result of them doing the bad thing. So you have to prove that they did something bad, which is their liability, and then you have to prove damages, which is how much what they did bad affected you. So it's a two-part test. Number one, they did something bad. Number two, this is how much it hurt me. If Earl proves they did something bad, but he can't show any dollar amount for how bad Earl was hurt, then he'd be limited to what's called nominal damages. You get $1. You were right. You get $1. There you go. Thanks for playing. Have a nice day. So if he says it's between $1,000 and $5,000, that means that they only proved $1,000 and $5,000 worth of damages.
Up to police misconduct, and they are giving up.
Lyncher says, but Verb, do sovereigns typically allow you to sue them for punitive damages at all? Well, I mean, do they allow you to sue for punitive damages? I don't know who exactly Earl is suing. It sounds like he's suing the police. 1983 lawsuits do allow you to sue the police, who are state employees, and the 1983, 42 U.S.C. 1983 is a federal law that does allow for punitive damages. So whether or not the state wants to or doesn't want to allow you to sue them for punitive damages doesn't really matter. And I can't speak for generally or typically, because that would involve knowledge of all 50 states plus the federal government. That's at least 51 sovereigns. And I mean, you tell me, Lyncher, why don't you get out your Google machine?
Thousands and thousands and hundreds of thousands, and in some cases over $1 million in damages.
Yeah, so $1 million or plus in damages will generally mean that someone was really effed up, like spinal injury, can't walk again, killed, something. That's going to be something pretty major. Just owie, he put my handcuffs on too tight. Yeah, that sucks. Here's your fairly nominal damages.
My lawsuit against the city of Deer Park is going to be for $3 billion.
This is where you get the Dr. Evil, $3 billion. Yeah. Again, you can put whatever number you want on your lawsuit. Now, due process requires that you inform the people you're suing of the amount of money you are suing them for. That puts them on notice so that they could figure out how much they want to defend. If it goes to default, you're limited by the amount of money that you pled in your complaint. Or like in California, there's a statement of damages or a statement of punitive damages that you would have to, a day in jail is worth $10,000 in settlement. Congratulations. All right. Settlements, that's worth in a settlement there is no formula for that. It's whatever you can negotiate in a settlement. But nice try, William Simmons. Where was I going? God, I wish I could play this back. Thinking. Yes, due process. So you're limited to what you can recover in a default by what you pled in the complaint. Now, if it doesn't go to default and you've pled just according to proof, then it's whatever gets proved in court. So putting in your complaint $3 billion doesn't mean anything. That would be just the limit to your recovery if it goes to a default judgment. But again, on the default judgment, you still have to prove your damages. So having a $3 billion limit, congratulations. That doesn't mean you're going to get $3 billion, even if it goes to, there is no formula, William Simmons. Trust me, a settlement is whatever you could settle for. There is no formula for settlements. It's whatever each side is willing to agree to. So you get the idea. You get the damages that you can prove. $3 billion is just a laughable number that he's never going to recover.
Let those numbers sink in, because I know Deer Park's watching. Let those numbers sink in. And I'm thinking,
Let those numbers sink in, because I know Deer Park is watching. I don't think Deer Park really gives a crap about you, Earl. I really don't. And throwing a big number, I mean, why not $3 trillion? Why not $3 gazillion? Why not infinity dollars, Earl? I mean, you could literally say whatever you want to.
to spell out how I'm going to get damages. Let's, I had a lawsuit filed out in California for copyright.
Yeah, how are you going to get damages on that, Earl?
How I'm going to get damages.
Yeah, how are you going to get damages? Like, what damage have you had? What costs can you associate with this?
Let's, I had a lawsuit filed out in California for copyright infringement on a video of mine, and I let it expire, and people are like, why'd you let that expire?
And I let it expire.
Expire. They won. They didn't win.
Yeah, so when your lawsuit gets dismissed, the other side won. Now, theoretically, he could refile it. There might be issues with that, and I'm not going to tell him the issues. He gets to figure it out on his own.
They did me a favor. You see,
We did you a favor by not doing anything and letting your lawsuit get dismissed. That's the biggest favor in the world.
one of the things you have to prove in your civil action is injury.
Yes, you have to prove injury. That's typically the wrong. Typically it's going to be like you have to prove there's duty, breach of duty, and injury that's related. That's legally approximately caused by the breach of duty. That's the liability side, and then damages are different than injury. You can be. I've used this example before. If a professional soccer player gets his hand cut off in an injury, he's going to have less damages than if a professional hard rock guitarist gets his hand cut off in an injury. Because the professional guitarist makes his money by playing the guitar. You need both hands to play the guitar. At least that's my understanding of the guitar work. Don't at me, bro. But he's going to have more damages than the soccer player who theoretically would not use his hands to play soccer. Again, don't at me, bro, if I'm wrong about that. So damages and injury are related, but they're not a one-for-one kind of comparison.
Damage. Okay? And by publishing that video unauthorized, they have given me damages.
I must have lost something there.
Prove in your civil action, they didn't win. They did me a favor. You see, one of the things you have to prove in your civil action is injury, damage. Okay? And by publishing that video unauthorized, they have given me damages. Think on that. But
Okay, I'm thinking on it. I must have missed something, but what?
let me show you what Deer Park PD is doing.
Oh, we're moving on. What the hell? Let me try this again.
Okay? And by publishing that video unauthorized, they have given me damages. Think on that.
What am I missing here? I'm missing something.
Out in California for copyright infringement on a video of mine, and I let it expire, and people are like, why'd you let that expire? They won. They didn't win. They did me a favor. You see, one of the things you have to prove in your civil action is injury, damage. Okay? And by publishing that video unauthorized, they have given me damages. Think on that. But let me...
That made absolutely no sense. I'm going to try that one more time because that made absolutely no sense.
Infringement on a video of mine. Let's, I had a lawsuit filed out in California for copyright infringement on a video of mine, and I let it expire, and people are like, why'd you let that expire? They won. They didn't win. They did me a favor. You see, one of the things you have to prove in your civil action is injury, damage, okay? And by publishing that video unauthorized, they have given me damages. Think on that.
But in order, okay, so yeah, we have to. So Earl would have to prove that we published his video. Yes, it depends on his theory of recovery, because the lawsuit that he had, there was I believe he alleged a statutory damage recovery, or a statutory recovery, which will not be based on damages. It's just a flat statutory recovery. But I don't understand how that relates to him allowing the lawsuit to get dismissed. None of that makes any sense to me. Us publishing the video we've already, any damage that would have accrued is already accrued because we've already published the video. And so him filing the lawsuit was to recover those damages. Him allowing the lawsuit to get dismissed does nothing to increase his damages, but it does make it appear that he's not willing to enforce his copyright claims. So I don't know. That's about the most retarded thing that I've ever heard. Anyway, as fun as this has been, I guess we're not going to get through everything. This has been a blast. I do have things I have to do this morning, so I apologize about cutting it off. We've only made it 16 minutes in, but I think we've been online for over an hour. Can a public record be defamation? I doubt it. That would be a hard thing to do. But anyway, I got to cut it. I'm sorry for leaving you guys hanging. I hope the whole video is as fun as all of this was. I might take up this later. I might not, but it's been real. It's been fun. Thanks for watching. Have a great day.